Mr. Stubbe.
Thank you, Mr. Chair. I yield my time to Chair Jordan.
I thank the gentleman. Mr. Shank, did Gail Wright really tell you that?
Yes.
Justice Alito said he didn't tell her. She said she didn't tell him, but you're sure she told you?
Absolutely.
All right, folks, buckle up, because today we've got one of those classic Jim Jordan moments where he absolutely dismantles a witness right in front of Congress. This wasn't just a heated back and forth. It was Jordan methodically pulling apart a story that simply didn't hold up.
Now, you wrote a book a couple of years ago, is that right? 2018, you wrote a book?
Yes.
I want to read a section from that book. It's a section where you relate you and your family attended oral arguments at the court. You were there in the courtroom, and that directly involved your brother Paul, also a reverend. And I just want to read this section. You said, with the single rap of the gavel, Chief Justice William Rehnquist announced, "We'll hear argument first this morning in number 95-1065, Reverend Paul Schenck and Dwight Saunders versus Pro-Choice Network of Western New York." Paul and I winked at each other, knowing we had made history with that reverend in his name. It had been a minor victory when we persuaded the court that reverend should remain before Paul's name, even though we had been told repeatedly that legal briefs never included such titles. You thought it was important that, obviously based on what you said, you thought it was important that the title Reverend be in front of Paul's name, is that right?
Correct.
And why was that?
Because we saw it as a religious liberty matter, and that would make it clear that it fit in that category.
Did Chief Justice Rehnquist really say that, the way I just read it from your book?
I can't say that I remember that.
Well, you're pretty darn specific here. You got the number, case number 95-1065. Very next word says Reverend Paul Schenck. You made it a big deal. Thought it's the first time it's ever happened. I'm just asking, did it really happen?
I wish I could tell. I would have to go back and review that.
So it may not have?
Possibly not.
Why do you say possibly not? You were emphatic in your book.
Jordan isn't letting this slide. He's got receipts. He pulls out the official transcript of the oral argument. And guess what? No reverend. It's just Paul Schenck. No special title. No big precedent-setting moment. Then Jordan ups the ante. He plays the audio recording, the actual words from Chief Justice Rehnquist himself. And again, no reverend. It simply didn't happen.
I would have to go back.
We did go back. We did go back, and I got the transcript right here. Proceedings, 10:05 a.m., Chief Justice Rehnquist. We'll hear argument first this morning in number 95-1065, Paul Schenck and Dwight Saunders versus Pro-Choice Network of Western New York. Did you hear it?
I did.
Was there a word missing?
Title Reverend.
Yeah, wasn't in there. In your book, you said it was a big deal, so much so that you winked at your brother. Did you wink at your brother?
Yes.
What'd you wink for if it wasn't in the title?
Well, it was our case.
But that's not, you said you winked because they included Reverend in the title, and the transcript says Mr. Rehnquist didn't.
Perhaps not.
Perhaps? Court reporter get it wrong? Did he say it and the court reporter get it wrong?
Well, then.
Well, we got the audio, too. I'm going to play that for everyone to hear.
We'll hear argument first this morning, number 95-1065, Paul Schenck and Dwight Saunders versus Pro-Choice Network of Western New York.
Reverend, did you hear that?
I did.
Was there a word missing that's different from what you put in your book?
A title, yes.
What was that title?
Reverend.
Reverend was not there. Right? Did you wink at your brother?
I think I did. In fact, I think I actually hooked him.
So now you got more details. You got the key detail wrong, what you were writing about in your book, but now you remember an additional detail. You not only winked, you elbowed your brother. Even though the reason for the wink in your writing was the fact that Reverend was using the title, something that had never been done, but it wasn't used. But we're supposed to believe you today. We're supposed to take your word over Justice Alito's word. We're supposed to take your word over a lady who gave you dollars donated to your cause, Miss Gail Wright. You're disparaging her name, Justice Alito's name, and the court. And you have this, which obviously didn't happen. We got the transcript, we got the audio, but you made it a big deal in your book. One thing I've learned, people who mislead folks on small things, mislead them on big things. And you know what? You can lie in a book, it's not a crime. You can lie to the New York Times, that's not a crime. But when you come in front of Congress and you say things that are not true, you're not allowed to do that. You're not supposed to do that. And we have seen it. You're not supposed to do that. I yield back.
That's the heart of it right there. Jim Jordan isn't just catching a guy misremembering. He's showing that credibility matters. If you want to come before Congress and accuse a sitting Supreme Court justice, Justice Alito, in this case, of misconduct, you better have your facts airtight. Because if you've been sloppy or misleading in the past, why should anyone believe you now? And Jordan drives it home with that brutal line. You can lie in a book, that's not a crime. You can lie to the New York Times, that's not a crime. But you can't come into Congress and lie under oath. That's where the line is drawn. To me, this exchange really highlights two things. First, Jim Jordan's skill as a questioner. He doesn't just raise his voice or posture for the cameras. He comes prepared with transcripts, with audio, with hard evidence. And second, it shows how shaky some of these accusations against conservative justices really are. People are willing to stretch the truth, to inflate stories, to make their narrative fit, even when the facts don't back them up. And that's dangerous, because at the end of the day, the Supreme Court's credibility matters. If we're going to have witnesses come in and accuse justices of impropriety, then those witnesses need to be above reproach. If they can't even get their own story straight, then the whole thing falls apart. Anyway, what do you think? Was Jim Jordan right to press so hard here? Or do you think the witness just made an honest mistake? Drop your thoughts in the comments below. And as always, if you found this breakdown helpful, don't forget to like, subscribe, and share. It really helps the channel keep going.